these solid waste. It was the Division of Solid Waste, which was a department under the Department of Public Works, and it was a Division of Solid Waste Management that was actually placed in receivership. And while that particular division was in receivership, the legislature passed a law that created the Guam Solid Waste Authority, which is an autonomous agency. So we thought that the most expedient and efficient way of promulgating these rules was to repeal that rather than rewrite it. Was to repeal the entire section and then take the existing rules that were adopted, and quite frankly, the receiver had, in its process of receivership, had educated the public, all of these rules and regulations and these standards are really a reflection of what's in place today. And so our goal, particularly in thinking that one of our underlying goals was to make sure that we met all of our requirements at the district court to be able to move out of receivership. We posited that to the court that we were just going to adopt the existing whatever rules and regulations, the existing policies that the receiver had put in place to create the efficient solid waste system that is in place and that they tout at all the quarterly hearings. And so that was our thinking, is we would simply repeal that rather than piecemeal, say replace this with this, replace it with this, repeal the entire section and put forward these new rules and regulations in place for the Guam Solid Waste Authority.
Okay, fine. So I kind of gathered that, and it seems like we just we did repeal in its entirety Title 29, but really did not cherry pick, so to speak, the good points. There were some good points in the old rules and regulations. For example, if we take a look at the proposed rules and regs, I don't see a provision in there, for example, that provides for an appeal. So let's say, especially a commercial hauler, there's the differences in opinions as to who's right, who's wrong. The GSWA management says, declares that you're wrong. Where does that customer go to appeal that? And if you were to take a look, and I guess probably the best example is Guam Waterworks. If there's a dispute over billing, over who's right or whatever, then after the general manager declares that the customer is in the wrong, the customer has the ability to go and appeal it to the general manager. And so there's that due process. I don't see that in this, unless maybe I missed it.
Off the top of my head, I don't know how that would be handled.
Yeah, so I don't think I missed it because I don't think it's in there. So I think that is something that needs to be considered, and maybe GSWA needs to provide language to the committee where we can insert that in here. In the old rules and regs, there is a provision in there relative to appeals. May I continue? Okay. In the rules, in the proposed rules and regs, in section 6202, in Article 2, 6202, page 6202, where's that?
Household hazardous waste?
Oh, here you go. Household hazardous waste. No, 6202, it's on, I believe it's not even paginated, this thing here. 6202, okay, we've got some duplication. We got a section 6202 has household hazardous waste program, And then we got a 6202 residential tipping fees and delinquent accounts. So we just need to go back and take a look at some of the formatting. But under what we have here as 6202 residential tipping fees and delinquent accounts, subparagraph L. Sorry, JKL. It reads here, customers may pay their bills with credit cards, but will be assessed the fee charged by the credit card companies. I'm just curious if GSWA did some kind of an analysis as to, you know, the additional fees that need to be, that GSWA may have to pay for allowing customers to pay with credit cards, whether it's worth having to bear that burden, but at least we, you know, the collection part of it is more effective. I know the other utilities, they've assessed that, but then, so basically we're saying no credit cards, and I'm just a little concerned about that. I know that the other utilities, they started off with that, and then I guess it got to a point where the burden got a little high, and then they had to reassess it. So I have some concerns about that. And then we also have, unfortunately, we have 26202 subparagraph L. So we have the 16202 subparagraph L regarding how customers may pay their bills. And then we have another 6202L regarding the non-permissible reason to deny or terminate service. Let me just read that particular one. It reads, GSWA may not deny or terminate service for delinquency in payment for services rendered to prior customers at the premises where service is being provided, except if it can be determined that there is intent between the parties to circumvent the provisions of these regulations and where the prior customer continues to reside in the premises. And so I kind of see a difficulty here from the standpoint, and again, my frame of reference is with the utilities, water and power, in that really, in order for you to apply for services, you've either got to be the leaseholder or you've got to be the landowner. And so I'm concerned that what happens then is, you know, the occupant one, he goes in and he applies for trash services, becomes delinquent on that, so we terminate that customer, and then tenant number two in the same house comes in and says, oh yeah, tenant number one left, and we have to provide them with services. And so that's kind of how I interpret that it could be a revolving door here, as opposed to the way they do it in the utilities. If the house is a rental unit, that landlord is ultimately, or the landowner or the landlord is ultimately responsible for that. So the tenants can come and go, and if the tenants don't live up to their responsibility, ultimately that landlord or the landowner has to pay the bill. So I'm concerned about that, and that's in 6202L, the second L. That's all I have with Article 2. I do have some questions on Article 3 regarding commercial accounts. I'll yield for now if you, okay. On Article 3, Section 6301, there's 6301B regarding private, commercial, or other non-governmental entities. And that particular paragraph says that a private commercial entity may open an account, but no curbside pickup will be provided. But it's not clear. GSWA does not provide any curbside solid waste collection or recycling services for commercial entities. So that's not clear. We don't. So I guess that's like, I don't know, would that be like a grocery, like one of the grocery stores? He can apply to, but GSWA won't pick up his waste. But where does he go? Does he go to the hauler only transfer station? Or I guess there's also mention made here about the residential transfer station. So I think we need to clarify where these private commercial entities that's mentioned in section 6301B, where do they go to dispose of their waste? In 6301C, we talk about government agencies. And in that paragraph, the last paragraph there, it says, mayors shall receive 1 free load of waste per day at GSWA facilities. Additional loads are charged in accordance with this chapter. And it just kind of begs the question, mayors receive 1 free load, but we don't quantify how large that load is. So he can come up with his pickup truck, or he can come up with a 1.5 and say, here's my 1 free trash for the day. So I think we probably need to be more clear as to the size of this free load that is to be allowed.
You know, that was, pardon me, I'm under the impression that is allowed by law. There's some other law that allows mayors to do that. At least that's kind of the impression I was given. It might have been a mistaken impression, but that was the impression I was given by the operations manager at Solid Waste Authority, the current operations manager, was that the mayors were allowed to do this, and there was some law that allowed them to do it. I guess this was just trying to reinforce that.
I'm vaguely aware that there was discussion on the floor about allowing mayors that, but I think if in fact that was passed as a piece of legislation, we probably should cite it in here that, you know, they are allowed 1 free load pursuant to public law, whatever. And I think down the road that's going to be important because I don't know about normally when we go out for bonds and whatnot, the lenders would certainly, usually in the covenant, it says specifically no free services. So we need to kind of tighten that up. It is not clear in the rules and regs how we treat delinquent GovGuam customers. It's pretty clear what happens to the residential customers. If he doesn't pay, he has up to 60 days, I guess, or it's payable upon invoicing. I think he has after 30 days. If he doesn't pay, he gets noticed. After 60 days, I guess he gets terminated. And then if he's going to come back online, there's a fee and whatnot. But I don't see in here, do we treat government customers the same? We talk about how the government agencies, they can dispose of their waste at the hauler-only transfer station, and then government of Guam customers will be issued invoices. But again, it's it's not clear whether we're going to treat the GovGuam agencies, customers, the same as we would residential customers and the commercial customers. So I think we need to clarify that. The term residential transfer station and hauler-only transfer station are used, but in the definition section, we don't clarify what is the difference between the two. I don't know whether the residential transfer station is the one that I see like in Harmon, in Agate, and if that is the one, then you know, maybe the rules and regs should more clearly state that. The hauler only, I don't know if that's the one in Harmon where the big trucks come up and the big containers get loaded and then they get hauled off to Luzon. It's not clear.
Just for the sake of you know, just for your own edification, that's the hauler-only transfer station.
So there's only one?
There's only one, and that's
okay.
From one perspective is that is a contract that is in place, you know, as part of the procedures that were the processes that were put in place by the receiver. So there are several major, you know, contracts. One is the handling of the hauler-only transfer station. One is, of course, the handling of the lads and landfill, the actual maintenance and work up there. So those are the major contracts that are allowed. And so there is a possibility that sometime in the future there would be a different hauler-only transfer station, or that the Solid Waste Authority could do something else in that regard. But I agree that we should define what they are, and not necessarily where they are, but just, you know, here is what is this is a hauler-only station means. It's where commercial providers bring their can bring their loads, or any commercial entities can bring their loads to the hauler-only transfer stations, etc. Residential transfer stations are for, you know, residents only. They're not for commercial entities.
Okay.
Right.
And then finally, the question that I have, and it actually kind of causes me some concern, is in Article 5 of the proposed rules and regs regarding radioactive waste. And it says here that in the event that the radioactive waste is detected in a load, that load will not be accepted. If the radioactive waste is brought to the facilities by a GSWA vehicle, said waste shall be placed in a secure container until the radiation subsides and material can be properly disposed. I guess once it gets put into a GSWA vehicle, it loses identity. And so it's our problem now. And so GSWA, then the waste shall be placed in a secure container until the radiation subsidies and material can be properly disposed. It just seems that probably that particular section needs a little bit more fleshing out. So how do we properly dispose it? Do we get a hold of, you know, whoever, and so I think section 6503 needs to be fleshed out a little bit more. Now section 6504 reads, if the radioactive material is brought to the facilities in a private or non-GSWA government vehicle, the waste will not be accepted, and the hauler can either, one, have GSA place the material placed in a secure container until the radiation subsides and the material can be properly disposed for a fee, or leave the facilities without depositing the material. The second option, to then turn that, whoever's coming to dispose of that, we're going to turn him away and say, nope, we don't want that. you go find, and I'm afraid that that's, if in fact there's radioactive waste in that vehicle, you know, it's going to end up in the boonies, like, you know. So I'm concerned with that Section 6504 in terms of the second option. That it seems that once that vehicle carrying the radioactive waste comes on, I guess we just got to impound it, and otherwise I'm afraid as to where it's going to go after if we turn them away. I presume radioactive wastes are going to be very hazardous.
Yeah, correct me if I'm wrong, but they're typically coming from hospitals. The hospitals, you know, when they're doing their nuclear studies for, you know, any type of treatments. I mean, that's where we're getting them, and they're, you know, they're supposed to. I mean, they're the reason that, you know, they get their permits for handling those because they're supposed to be, you know, they've committed to handling the disposal of those radioactive waste properly.
To be properly contained.
Yeah, that's really what this is referring to is from hospitals.
Yeah. So just kind of reading that, just kind of scary, especially that last one there about, well, go away with your radioactive waste, and you're not going to deposit it here. So those two sections of Article 5 are the two sections that just causes me a little bit of concern, and that's all I got, Madam Chair.
Thank you, Senator Atta. Mr. Gill, Senator Atta brought up several concerns, and I noticed that you weren't addressing each and every item that he brought up, so I'm hoping that we can perhaps come back and address these concerns and make the changes to the rules and regulations. I understand it went through the Attorney General's office and it was approved. However, some of the concerns that we have here at the legislature is still very vital. A question I have in your EIS, your GSWA operational rules and regulations, you have the economic impact, and on the last page, the first paragraph, under the GSWA's Enabling Act and subsequent legislation, it must petition to the Public Utilities Commission within 180 days of the termination of the receivership to either ratify or modify the current tipping rates. Until then, the current rates will remain the same. So I'm thinking that we're looking at June 30th to be the termination of the federal receivership. And I know that in some of the court hearings, there's been perhaps a notion or an implication that the rates may have to increase for one reason or another. So could you perhaps just speak about that? Because I remember you speaking about that early on, and even in some of the informational hearings that we've had before.
Well, yeah, sure. So what this is talking about is this specific reference that you cited refers to the fact that the law that was passed a few months ago requires us to ratify the rates. The rates that are currently in place were never put before the PUC. They were proposed to the court, and the court adopted them. And the receiver justified the rates based on his current revenue requirements, operational requirements, etc. What we were proposing, or the intent was that after receivership ends and the management team is put in place under the Solid Waste Authority, that was been hired by the Guam Solid Waste Authority Board of Directors, that we reevaluate what those requirements are, and those requirements would include any operational expenses and any other expenses that would be borne by the Solid Waste Authority to determine what the proper rates would be going forward. I mean, that's just the typical way you would do any kind of rate case in front of the PUC. Because in order to get rates adopted by the PUC, you say, here are my rates, and they say, okay, well, how did you come up with those rates? I mean, that's just what they do.
And what concretely do you foresee if you would have to request for the PUC for a rate increase?
I'm not saying I have to request for an increase I'm not saying that.
Okay.
I'm just saying that we would evaluate what our requirements, what our operational expense requirements would be, as well as any reserves that would have to be maintained in order to fulfill our requirements as a municipal solid waste system. So the part of that is going to be dictated by the plan that is still in place with the court, which means there will still be a trustee in place after receivership ends. Right, so the trustee there will still be a trustee in place appointed by the court, paid for. Commercial revenues, roughly 60% of the revenue of the GSWA would go to the trustee. The trustee would make sure that the ORDOT cap, the cap of the ORDOT dump is maintained, and then remit the rest of the money to the agency for its operational expenses, plus any other reserves for future cells, equipment reserves, etc.
What is the cost of the trustee that is in place, that will be in place?
That is, the bid for that hasn't gone out yet, I don't believe, right? And so we're unsure what that cost will be. The idea is it'll be, a person or a firm that will basically be handling that. And
is there a trustee in place now for the federal receivership?
No, the receiver is essentially the trustee.
Okay, yeah. So now we're going to have to anticipate an additional cost by court order for a trustee that is you have yet to put out a bid for one.
Right, so that is being handled by the receiver. There will be a trustee that will be put in place. The trustee, there will also be for the whole thing, there will be an engineering firm that will be hired to maintain the cap. And that's been selected. Brown and Caldwell has been selected, and so there's a cost associated with that. There's going to be an independent engineer that'll be hired to oversee the work that Brown and Caldwell does in maintaining the cap. They're essentially the cap operator. The engineer is observing. A qualified engineer is making sure the cap operator is doing their job, and then the trustee is making sure they're getting paid and making sure they're meeting their requirements and paying them properly, and then they do that with the fees from the commercial tipping fees, and then the remainder gets given to the Solid Waste Authority.
Thank you. And and that's some of the things that I'm hoping to have a better picture of, because.
Well, you and I both.
Okay. Okay, then I guess perhaps we're on the same page. We don't really know and anticipate the exact monetary impact that it's going to have on GSWA and also the customers as well. But I think this is something that needs to be considered, and we should talk about it more openly.
Yes. Again, as our mandate at the Guam Solid Waste Authority is to make sure we provide a municipal solid waste system that meets all federal and local requirements, and so that's our number one priority. I mean, that's how we got into this into the receivership in the first place, right? And so that's really our mandate, as put forth by this legislature, the legislation that Mr. Senator Atta authored. In order for us to one, get out of receivership and then have a properly maintained municipal solid waste system is to make sure we address those regulations, both federal and local. So that's our mandate, and making sure that we have the reserves and the money from our fees, from our revenues, from the system revenues, in order to be able to fulfill those requirements.
Okay. And is there still any concern that Frances Tedinko Gatewood is there still any concerns that she has about the termination of the federal receivership into GSWA's operations, or is everything amenable, and she's confident now that as the board you guys are ready to take this on? And
I cannot read the judge's mind. At the last hearing, we were going to present a transition plan, but she cut that short. We can transition out of receivership. We've hired a qualified management team. We've worked with this legislature, making sure we've got our certain requirements when it comes to the contractual obligations and our employee transitions in place. We're working on the rules and regulations to try to make sure that they're in place and adopted before we proceed. To tell you the truth, I'm not sure if the judge will delay any process depending on the status of this or not, of these rules and regulations or not. I just don't know. I can't sit here and tell you that it will or it will not impact that timeline.
Okay. In your personnel transition, it states that Board Chairman Gale directed Mr. Martin to look into the contracts and make sure that the contracts will continue after the transition date. This is in your board meeting minutes. Has that been solidified? How long will the contracts continue? What is the transition for that?
Well, when we talk about personnel transitions,
yes,
there are just the contract with PHR, and the representatives are behind here, and so as I understand it, we've received assurances that we can, if not continue existing contract, enter a new contract for those contract employees. So we received their assurances. They're also working with us on our classification plan for existing contract employees to allow them a path to become Government of Guam employees.
Right, because you must have a high school diploma or
yeah, right.
Or
You need to follow all of the requirements to become a GovGuam employee and then to avail of the civil service protections,
right,
as specified, and all the rules that come with it. That's correct.
So the extension of the personnel would be until 3 years,
Oh.
and then hopefully they have a track that will allow them to meet the requirement of the current government law to be a government employee. Is that the intention, or?
Well, the intention is to analyze. The intent is to make sure that we are still able to function as a municipal solid waste system.
Okay.
That after the day one after transition, there's no hiccup. That we'll still be able to. Garbage will be picked up. Bills will be collected. The landfill will still accept. Municipal solid waste. I mean, that is the intention. We also want to have our management team evaluate the operational requirements of the Solid Waste Authority post-receivership to ensure that we're operating, as efficiently as we can within the confines of a municipal solid waste system that is an autonomous agency of the Government of Guam. There are certain things that we cannot do that the receiver was able to do. We just need to make sure that we're able to operate within those confines and fulfill our regulatory requirements.
Okay, thank you, Mr. Gills.
Regarding the economic impact, the current tipping fees that we have, is that the same level of tipping fees that were put in place since 2008 when the receiver took over?
No,
I'm sorry, here it says the receiver with the district court's approval set the current tipping rates in 2009. So that would be about nine years ago. Do you know if the current tipping rates is an increase level than what it was back in 2009?
Yes, they're higher.
So the tipping rates has been increased.
Yeah, they were these. If you recall, I recall from a residential perspective, pre-receivership, it was $10 a month, and then it was raised in increments to $30 a month. And then I believe I can't remember what the commercial rate was, but
right.
But this commercial rate has been in place for several years now. This 171.60 per ton.
So when was the last time that we had any adjustment? It's not. Well,
it's been more than 5 years, because I remember in 2013 when I first became the member of the board of directors, there was a rate study that was submitted to the court that talked about the rate requirements if an alternate landfill was started to dispose of incinerator waste, right? So that was the original rate study that was done back in 2000. I want to say 2013, 2004, 2012, 2012, and at that time the current rates were the same, $30 for residential and $171 per ton. That rate study said basically that rate study said, look, if the revenue that's created by the Solid Waste Authority is primarily from residential pickup, about 40%, and 60% comes from waste that is delivered and dumped, and we charge per ton. If some of that goes away, if all of a sudden we're not getting the same revenue amount, instead of getting 100,000 tons a year, we get 50,000 tons a year. Well, then our revenue decreases, but we still have certain fixed costs. And so based on that study, on those things, saying if you divert this much waste away from this landfill was designed for this, et cetera, and here's the amount of fixed costs, then you're going to have to increase the rates. Now, that was what that rate said. Now, we're not, as you know, there's no incinerator that's approved. We don't have any anticipation of any diversion of waste. The projection of the waste going forward falls within 1 or 2%. So we don't anticipate a large change in any type of revenue coming into the Solid Waste Authority.
So here's the concern that I have regarding the tipping fees. If we assume that right now, I believe GSWA is generating about $19 million a year just from tipping fees.
That is correct.
But it's also receiving a subsidy of about $12 million from Section 30 money?
I wouldn't characterize it that way, Senator. I would characterize it in the fact that the Solid Waste Authority is not using any of that $19 million to pay debt service.
Correct. Okay, but so the debt service, there is a debt service out there.
Right. But technically the debt doesn't. It's a Section 30 debt that was based on that is really not directly tied to the Solid Waste Authority. It's pledged. It was pledged at the government of Guam.
And the concern, of course, has been because the current governor has suggested that probably GSWA should pay completely for everything, to include the payment of the debt service. And if it does that, if the government decides to take away that Section 30 money that's paying for the debt service, for sure that's going to jack up the tipping fees. But let's assume for the moment that the current revenue streams are going to stay as is.
Right.
Some from Section 30 and then from the tipping fees.
Again, I wouldn't characterize revenue from Section 30 as solid waste revenue.
That's right. Yeah,
right.
It's not.
Right.
It's not.
It's just not. We're not. There was an arrangement, and Solid Waste Authority was paying debt service to the tune of about $4.5 million a year up till about 2013 or 2004. I can't remember the exact date. And then the receiver petitioned the court to stop paying that debt service in order to maintain those funds for reserves, for consent decree project-related reserves. And so that is, and that's still happening today. Those monies are not being remitted to the general fund.
Do you know if the debt service schedule, if there's going to be projected increase in the annual debt service according to some schedule?
Yeah, that happened already. At least from what I'm familiar with. I'm not an expert in this, but what happened was the debt service was about $4.5 million, and then there was an increase to about Well, actually, I think the debt service was a little bit higher, and then there was an increase. And so there was a study done and an agreement made that the GSWA would be responsible for 75% of the debt service, based on the fact that, look, it's for opening up the landfill, but then the portion that was for capping the dump really shouldn't be borne by future ratepayers, and so it should be borne by the government of Guam, who should have withheld some money. So there was a 75% figure, and the $4.5 million was roughly 75%, so there was a $6 million debt service number. And then that jumped to about $16 million. And so then the debt service that Solid Waste Authority was supposed to pay was about 11 or 12 million dollars based on the increased debt service. I believe there was a rate study done based on that debt service. If we were to bear all that debt service, and the rates would definitely have to go up if the Solid Waste Authority had to bear the debt service. That's just, we're a $19 million revenue company. If you had $12 million in debt service, it's huge.
That's right. But my question was, the current debt service schedule, I think, requires about $12 million a year. What's the current annual debt
I think
service?
the total on that particular bond, I believe, is about 16 million. But I think, according to agreements and whatever was done in the past, the idea was the Solid Waste Authority would pay about 12 million.
Right.
I think that was the original.
But is that debt service going to be basically the same over the next 10 years or whatever, or is it expected to increase? What I'm getting at is
I think it was that particular bond was refinanced, I believe, just a year ago or two, and there was they changed for a balloon payment at the end. I believe, again, I'm not completely sure. And then, because what happened was that was one of the things that was proposed in the court by Gov Guam as part of our finance plan. Hey, we'll refinance this, we'll change this out, and we'll go forward. And the court said, no, we're going to go with the receiver's finance plan. So that's where the trustee, et cetera. So, but what Gov Guam did was they refinanced that bond, and I believe they used a portion of those. They used the money that they got up front to pay debt at the hospital.
Okay.
To pay bills at the hospital.
Here's what my concern is, and I just want to put it on the record, is that I'm not sure if the schedule of payments is due for another bump up, or are we at a point now where whatever that annual debt service is, it's going to be like that up for another 10 years and then it balloons, right? Or is it scheduled for the next bump up here in the next couple of hours? And I say this, I'm bringing this up because we make the statement in the economic impact statement that the current tipping fees is really nothing new. The community has already adjusted to it pretty much over the past several years. So nothing new here, but the concern that I have is that these rates have been in place since 2009. And we know that the cost of operation is increasing, the cost of fuel, the cost of labor. And so at some point, the $30 a month residential tipping fee is going to need to be adjusted to be able to account for those increases. So unless we are, really clear when we say that there's no impact, because this is what we've been, this is what's been in place for the last.
Right. Again, the idea behind this economic impact statement would be, what would be the economic impact statement of promulgating these specific rules and regulations?
Right.
And we anticipated, based on what we foresee for the next few years, no impact. We don't anticipate that by promulgating these specific rules and regulations that there will be an impact in the rates. We're not proposing that, and that's what that impact statement says. It doesn't speak to, and nor was it intended to speak to, any future debt service.
Or increase in operating costs that the current tipping fee levels will not be able to cover.
But again, for the impact for this particular rules and regulations, we didn't speak to that. You're right.
I can see where they're kind of really separate issues, but I just want to make sure that.
As we understood it, the requirement for the economic impact statement would be specific to what these rules might do. Like, for instance, if we put in a rule here that said, you've got to, I don't know, something that, a specific rule that increase our costs somehow.
Right.
Right, but our intent was we wanted to maintain the exact same operation that is in place today, and that these rules are meant to ratify that, and that there would be no, thus there would be no impact to there would be no economic impact.
Okay. I have just one final question, and this is going back to the operations rules and regs. I did not see anything in here about green waste. I know that right now, or at least the only place I've seen it is there's a little sticker on my bin that says no green waste is allowed, or yard waste. I don't recall seeing that in the rules and regs about, not allowing green waste.
Okay.
Okay. That's all I have. Thank you.
Thank you, Senator Atta. And Mr. Gill, that's exactly what I was getting at, is because Senator Atta has brought up several points about the debt service. What we don't want to acknowledge is $12 million being given in Section 30 funds to offset some of the payments to GSWA, which is really unclear for us, and the anticipation of the rate increases. But also, I do remember this in the hearing where the federal receivership has put aside $4.5 million since 2013. What is going to happen with that money?
So those monies are in a reserve,
right?
That are being held by the receiver for specific purposes. The reserves handle future maintenance of the ORDOT cap. It'll handle the equipment and handle the closure of existing cells at Ladzon. It'll handle the opening of new cells at Ladzon. Those are the idea behind the reserves for any municipal solid waste system. So right now I believe the balance.
Thank you. That would have been my next question.
It's in the 20 million. I believe I think I saw was watching your budget hearings a while ago, and that when you had the DOA here, and that fund was mentioned. Yeah. It's about $20-some million in there. And
this is specifically for GSWA for the maintenance.
Well, yeah, it's held in trust by the receiver. The receiver has those funds.
And then when we transition after June 30th, will the trustee oversee this reserves? What happens after the transition?
No, the trustee will be in charge of maintaining reserves for the ORDOT cap.
Okay.
The reserves required for the Ladzon landfill, opening future cells, closing existing cells, equipment reserve, all of those will be handled by the Guam Solid Waste Authority.
Okay. And so is this are you pulling from different reserves, or is this whole $20 million going to go to the trustees' appointment and then also to GSWA? How are you separating the money? Is this money going to be separated for both projects, or are you?
Well, yeah. The trustee will control the way I understand it. The trustee will control the money for the ORDOT, for the maintenance of the ORDOT cap, right? So that's why 60% of the commercial tipping fees will get paid to the.
No, I understand, but I'm asking about the reserves. Who's going to control the reserves, and how does it get?
Well, the reserve for the Guam Solid Waste Authority will be controlled by the Guam Solid Waste Authority.
Okay. And so what do you plan on doing with the reserves? Is it specifically for Ladzon landfill, or are you also going to work with the appointed trustee that the court ordered you to get for ORDOT dump? Where's the reserves going, really? I mean,
well again, two different reserves.
Okay, so there's two different reserves.
One reserve will be held by the trustee that will
Okay.
handle the maintenance of the ORDOT cap. The other reserve would be for the Guam Solid Waste Authority to handle its responsibilities.
And the ORDOT cap is the money coming in from the commercial tipping fees?
Right.
Okay. Okay. Well, I do want to see if we can hold another public hearing, but we have to check the timeline to address some of the issues that was brought about and to talk about some of the corrections, whether you deem necessary or not. I think that a lot of things that Senator Ada did bring up is very necessary to address. But of course, we'd have to check with the timeline if we can hold a second public hearing to address some of the concerns that we have here at the legislature. And I'd hope that we have a more open dialogue about the debt service impact, the possibility of I guess the peak in the debt service, and then also how it would impact GSWA and the customers, which is basically the people of our island. Senator Adam, do you have anything to say?
When's the next status hearing schedule?
Yeah, it's going to be in May sometime.
It's going to be in May. So so our timeline here at the legislature is that the next session is going to be April 23rd, and then the next session will be sometime in the last week of May. And then after that, we probably won't see another session until July. Now, I believe the rules and regs, having a set of approved rules and regs, is going to be a key piece in the district court's decision to allow the transition from the receiver to GSWA. So maybe we should take a look at the timelines from that standpoint.
I believe there are emergency rules. I believe the AAL allows for emergency promulgation of rules, so we're not.
But those emergency rules are only good for 180 days, right. Which allows you then time, allows GSWA to be able to formulate a set of rules and regs and get it approved.
Right.
So I believe, I'm not sure when that 180 days comes up, but regardless, the district court, I'm sure, is going to be looking first. Do we have, a set of approved rules and regs? And so if we go in May and the legislature doesn't act on this by the time that, do we know exactly when in May is that district?
May 11th?
May 11th. So if we don't catch the April 23rd window, then we're going to come in kind of short-handed, I guess, when we go in for the next status hearing in May. And I only bring that up from the standpoint that maybe a roundtable discussion that will address the concerns that were raised. Maybe we should consider doing that as early as maybe actually, next week or the end of this week, and then hopefully be able to get a committee report out and get it put on the session agenda next week.
Okay. So please anticipate that we are going to meet again in a short suspense. If you can address the concerns and then perhaps make some changes to the rules and regulations, of course, as you see fit, and then maybe have a little bit more information as far as the anticipation of the rates, the transition of costs. I don't know if you even anticipated cost analysis. I know that you want to get the rules and regulations in place, and I know that I understand that the economic impact was specifically for the rules and regulations, but I think there's also concerns about what's going to happen after the transition that we need to discuss. So if we can work on that, and my team will get with all of the members of the board to schedule something so that we can have this addressed before you go before the district court in May. Okay, thank you very much. This concludes our public hearing. It is now 11:09 a.m. Thank you and God bless.